for Counterpoint, your vidcast that talks about consumer-related issues, mostly in the class action space. I'm one of your hosts, Christine Argentine, partner at Cypher Shaw in our Chicago office.
And I'm Paul Yovanik, and I'm a senior associate in the Chicago office of Cypher Shaw. And today we're going to be talking about the TCPA, a little bit about its background, and where we're at today, what we're seeing coming out of the courts. And so, Christine, if you can tell us a little bit about that.
Yeah, so what we wanted to talk about today was the McKesson decision that came out of the Supreme Court this year, because it really has created quite the opportunity in the TCPA world to kind of reevaluate some of the interpretations that have been kind of a foregone conclusion for many, many years in TCPA litigation. So the McLaughlin Chiropractic versus McKesson decision, essentially the holding there was that the Hobbs Act does not bind district courts to an agency's interpretation of a statute, right? So instead, it said district courts have to determine the meaning of the law under the statute based on ordinary principles of statutory interpretation, right? They get to look at the statute anew and decide, independent of what the FCC has said, how the FCC has interpreted the statutes, decide what is the proper statutory interpretation based on ordinary principles.
Okay, and so I guess, we're talking about FCC, and we're just trying to, for our viewers, where does the FCC come into play with the TCPA, and why are we fighting this FCC issue?
Yeah, and so I want to be clear, right? It's not, the McKesson decision isn't just about the TCPA, but its application does apply to the TCPA when we talk about the FCC, because what the TCPA did was it gave the Federal Communications Commission, the FCC, the authority to promulgate rules based on and to interpret the TCPA language, right? And so essentially it's a federal agency that's interpreting and has been putting out orders for many years about the interpretation of the TCPA and what applies and what doesn't. And it also obviously has promulgated rules under like the DNC rule under the TCPA. It's the one that established the do not call list.
So it just seems like there was almost just, I think you alluded to it, this assumption that FCC interpretation was binding on courts, and this McKesson decision really kind of just puts that back.
That's right. So for many years, right, the FCC has issued orders about the TCPA and how it's interpreting those rules and how it applies. And so courts have deferred to that agency's interpretation. And for the most part, it's become kind of principled within the litigation that the FCC orders are, binding more or less, right? That the courts are definitely have deferred to them.
Courts are saying, well, the FCC said this, so I don't have to even interpret the statute anymore. The FCC has done my job.
I mean, and to be fair, no one really has even raised those challenges for many years, right? The parties agree.
The foregone conclusion of just this is it. Okay.
Right. So for purposes of the TCPA, right, that means district courts are no longer bound by the FCC interpretation, right? The McKesson decision has essentially told them, go back and look at the statutory interpretation anew when it's raised in your cases. And so this has come up so far in two primary areas, right? So the first area that we've seen it in is whether or not a residential subscriber under 227C, so there's two kind of primary areas of the TCPA. There's 227B, which talks about auto dialers, pre-recorded messages, artificial voices. And then there's 227C, which is where the TCPA gave the FCC authority to make the rules, like establish the DNC list. That's where the quiet hours falls. Those rules all fall under 227C. Okay, so we've seen some challenges in district courts to whether or not a residential subscriber includes cell phones, right?
Yeah.
Or is it landlines?
Okay.
Right.
And obviously the assumption of just, text messages and everything is just something that we've seen through the FCC, correct?
That's right. And so the FCC has said a residential subscriber, which really falls under the DNC violations, right? Because the DNC list was established to basically protect residential subscribers, that's the language, from, where they object to receiving, calls and messages, so that you can put yourself on a DNC list and say,
Sure.
I don't want to receive these telephone solicitations, right? It's specific to marketing. And so the question is, what does residential subscribers mean? And so the argument on the defense side is that doesn't include cell phones. It includes landlines when we're talking about residential subscribers.
And how have courts have been responding to that yet?
So that one has fallen a little flat with courts so far. So we've had 3 courts reject that defense interpretation, right? So we've had the Northern District of Georgia, the Middle District of Florida, and the District of Oregon all come out and say, we don't buy it.
Sure.
Our interpretation of the TCPA is that residential subscribers does include cell phones.
Okay.
Right? And when they're talking about that, what the courts have said in their kind of renewed look at the statute and statutory interpretation is that the word residential modifies the word subscriber. So whereas the defense kind of says we're talking about the type of technology, right? Landlines versus cell phones.
Like a residential line being a
That's
landline
right.
at home, and not a residential line meaning my cell phone number.
That's right. The courts have said it doesn't this is not talking about technology. This is talking about the subscriber itself.
So that's to say that a commercial landline, that argument wouldn't work for that, or that would work for a commercial landline?
That's the distinction that the courts are making, right?
Okay.
Is the subscriber using the technology for personal purposes, or are they using it for commercial
Sure.
purposes? So that's where the line is drawn when you're talking about the word subscriber.
Okay.
And so the courts have said, listen, people use their cell phone for personal reasons, as they do landlines for personal reasons. And so you are a residential subscriber if you are using your phone, your technology, for personal reasons only and not for business purposes.
Okay.
Right? So, and I think what the courts have said is that really aligns with the purpose of the TCPA. And what's interesting is a couple of the courts have kind of specifically said it doesn't make sense to tie residential privacy interests to what has essentially become an obsolete technology, right? When I grew up, my parents had a landline. They don't anymore.
So if it's
I don't
tied-
have a landline.
Right. If it's tied to just residential, then TCPA doesn't work anymore.
That's right.
Right.
Right. So I think courts will continue to kind of go that way on that question, but it's an interesting one, and right, it's one that was ripe for challenge after this McKesson decision.
Sure.
The other area, which has been a little bit more mixed, is whether or not text messages are included in the private right of action under 227C.
Okay.
Okay, so the private right of action allowed for under 227C says you have a private right of action if you are a person who has received more than one telephone call within a 12-month period on behalf of the same entity in violation of the prescribed regulations.
And a text message is arguably not a telephone call.
Not a telephone call, right? So that's what the defense has argued, is that this specifically says, the statutory language says telephone call, and that cannot be interpreted as text message.
So we've seen courts picking up on that a little bit?
We have. So we've seen, again, 3 decisions here. So we've seen the Central District of California and the Northern District of Florida both say, yeah, that's our interpretation. You cannot interpret telephone call. The plain, ordinary meaning of telephone call isn't a text message. And then the District of Oregon has gone against that decision, almost actually, I think it was the same day or the day after the Central District of Illinois made its ruling. The District of Oregon disagreed and said, no, to align with the purpose of the TCPA, this is going to include text messages. I think what's interesting here about this question is you do really have that very specific language in the statute that says telephone call.
Right.
And in one of these cases, the defense made kind of the very obvious argument of, listen, if I'm going to call Paul, I'm never going to say I'm going to text him and you're going to interpret that as a call,
right,
and vice versa,
right?
There's no confusion
and
ambiguity about that language.
You're going to call or you're going to text. We know the difference.
Right. Now, the plaintiffs have argued, and I think it's a good argument, that, listen, this is part of the purpose, right? We want to give the broadest possible protection to people, and text messages are a technology, a thing that businesses are using very often now. And so we shouldn't be limiting, and they said that Congress wouldn't have limited or wanted to limit the scope of the private right of action when text messages are otherwise covered by the TCPA.
Right, right.
The courts rejected that argument, or at least two of them did, and said Congress limits private rights of action all the time.
Sure.
Right? Just because the statute itself is broader and covers more areas, it doesn't mean that the private right of action has to cover all those areas, right? We see it with the CCPA too, right, which only covers kind of the breach pieces,
right?
Even though the statute itself has a whole lot more regulations in it.
Right. But it all kind of starts with a breach.
That's right.
Right.
And so courts have said, it's not unnecessarily that the Congress wanted to include text messages. And by the way, we, the courts, can't make that decision for them.
Sure.
If they want to come in and include text messages, Congress can do that. But as we read the statute, our job is to look at the ordinary language, and the ordinary language says telephone call.
Right.
So I think, it's great for the defense if that challenge keeps working. There's a lot of cases out there that are based solely on text messages that would be open to a motion to dismiss or a motion for judgment on the pleadings or a summary judgment motion.
Sure.
Based on this new statutory language. It's a little early to tell kind of how it's going to lay out, right? We've got two decisions on one side, one on
right.
the other. It could go either way.
Obviously, appellate courts are probably going to eventually weigh in on this as well, if not higher.
Right.
Following McKesson, we've talked about a couple scenarios we've seen. Are there any other areas in TCPA that you think that this McKesson decision might, set up for challenge?
Yeah, I think there's a lot within the regulations. There's a lot that the FCC has done over the years through orders and in the regulations that are up for challenge, right? The quiet hours being one of them, whether or not quiet hours fit within a private right of action under 227C, whether, what applies to that. I think all of that is kind of up for challenge now. Now, keep in mind, right, it's not that the FCC orders or their opinions are going to be blatantly ignored.
No.
Right? And actually, the McKesson court said, the district court should independently determine for itself whether the agency's interpretation of the statute is correct, affording appropriate respect to the agency's determination.
So it's allowing. It's requiring the judges to do its own independent review of, okay, let's look at the FCC guidance on this, and if I don't agree with it and I'm interpreting the statute differently, I'm allowed to do so.
You're allowed to do so.
And so it just seems like we're going to just, the defense, I think, for strategically are going to be looking at, all right, our playbook on defending TCPA might have to partially go out the window because there's some stuff that we've just assumed arguments can't be made on, or it's just going to fall flat. Maybe it doesn't.
That's right. And again, the court can respect what the agency has done.
Sure.
Obviously, the agency and the commission has done research and really spent a lot of time looking into this area, and so they can, afford appropriate, deference. Mm-hmm. Deference isn't the right word, but they can look to those for persuasive value. Sure. But they have to use the standard principles of statutory interpretation.
Sure.
And again, that's why the kind of telephone call versus text message is such a good example, right? Because you look at the word of the statute, what the intention was, the best way, statutory principles, the best way to understand the intention of Congress is what's the ordinary meaning of the words that exist in the statute.
Exactly.
And that's what they did. So we'll obviously keep everyone updated as more opinions roll out, as more challenges come up. But I think this is going to be a really interesting year for the TCPA as all of these kind of pieces that we assumed, these interpretations that we just assumed were, the law now can kind of get overturned or at least challenged.
Great. Thank you.
Thanks.